we propose that time be equitably allocated. If he's having 2 hours, we need 6 hours. 12 hours of resignation. Each of these is entitled to cross-examine time. We demand an equal and equitable allocation of time as a matter of principle. I do not think it will be in the interest of justice that the petition is rushed to the prejudice of the respondents. We have noted that decisions have been made consistently in favor of the petitioner and at the expense of the rights of the respondents, and we shall not sit back and wait for more decisions to be made in similar fashion. At least the much we can benefit and claim for the petitioner is sufficient time, unless otherwise there are such other instructions that have been issued for reasonable constraint of time. Thank you.
Councillor Shifoka, for the respondent, we have consulted and shared on your concerns. The petition has been allocated 2 hours to present his case. That is giving evidence in chief. We have allocated the respondents through you 1 hour of cross-examination. You must take note that we served you with a schedule of these proceedings on how we shall be proceeding. You never protested on the issue of allocation of time so that we could deliberate on the same at those initial stages. But also please take note that we have 6 respondents, and each and every of the respondents has been allocated also 2 hours to present their defense when they'll be giving their evidence. Each and every of them has been given 2 hours, and in turn, the petitioner has been granted 1 hour for cross-examination. The 2 hours given for the petitioner to present his case, it is respectively given to the respondents when they shall be giving their evidence in chief. So please, there is a schedule. Let us comply. Let us abide by that schedule, and please let us proceed. Counsel for the petitioner.
Honorable Chair, you do realize that the petitioner has 6 hours for cross-examination only. We have 2 hours for cross-examination. I'm saying it can't work. It's not possible. You realize there are 52 different issues raised in the affidavit in support of the petition. We intend to ask at least 1 question per issue. There are some we will ask 3. There are others we shall ask 5 questions. Even if the petitioner will take 1 hour to respond to each, that simply means it cannot work. So when you do aggregate the time being allocated to the respondents, you realize that it is deliberately skewed against the respondents. And that is why we say the minimum we can have to trust in the fairness of this process is equal time, or even equitable time allocation. Otherwise, we cannot come here. You know, they do not need to testify. They may even keep quiet when their time comes. So we need sufficient time for cross-examination. We cannot acquiesce to an infringement. We have consistently said, you, the committee, delayed in the processing of this petition. You received the petition on 12th of October. You committed it.
Council,
It is not until
please, Council,
it is not until 20th of November, over 1 month, that you have effected service.
Council Shifoka, we shall not allow that. Please,
So if the
let us not go that direction, Council Shifoka. We can't be talking as an arbiter, you are also talking. When we take a microphone, let us listen to one another. Let us have a sober engagement, Council Shifoka. You cannot now start again accusing the committee on how we process the petition until the time we are here. Please, Council Shifoka, we have directed and we served you with the schedule of these proceedings. We are directing as a committee that please let us proceed. If the committee feels that you have exhaustively taken your 1 hour and we feel that we should give you an additional time, we shall consider that. But let us not go that direction that we are going. Please, we directing that the committee, if the committee feels that we need to accord you some additional time, we shall get there. All is not casting stones.
Honorable Chair, we feel threatened. We feel threatened by the rigid position being taken, and we want safety of time. So if we are safe, we want the issue of cross-examination time being clarified once and for all. We do not want under constraint of time.
Thank you, Council Shifoka. And the committee can see how you seriously represent your clients, but let us abide by these directions, Council Shifoka. And with due respect, all is not casting stones. We served with a schedule on how these proceedings shall be conducted. Let counsel for the petitioner place the petitioner on stand. Let them present their case. You begin cross-examination, and at the lapse of 1 hour, the committee shall reconsider. If at all you shall need an additional time, the committee shall deliberate, reconsider, and see in the circumstances and in the best interest of justice on the additional time we can grant you. If at all you shall reach there when you need some time. Please, we are
Honorable Chair. My fear is, yes.
Council Shifoka, let me finish before you take the stand.
My fear.
Let me finish before you take the stand, Council Shifoka. I haven't finished giving the directions of the committee. So if at all we get to the tail end of your cross-examination, and you need some time, we shall reconsider that. You've alluded to the fact of the safety of yourself and the respondents. We are telling you and assuring you as a committee that we are conducting these proceedings in an open forum and in public, and the safety of each and every one of us is guaranteed. Council Shifoka, please let us abide by the directions of the committee. And those are the directions of the committee. And please, counsel for the petitioner, take the stand. Let the petitioner begin.
Yeah, one request. I want to go expressly on record that when the time comes and we seek for more time, the same shall be granted, and not to be mischievously granted, so that we are granted 2 minutes for further cross-examination, that we shall be granted sufficient time. And 2, I would also wish to make a request of the ruling delivered regarding the remarks made by the petitioner earlier on, preferably by the end of the day today. Thank you.
Council Shifoka, that shall be the direction, the decision of the committee when time comes. We shall consider that application when time comes. Thank you.
Proceed, petitioner.
Thank you.
Then sorry for interjection, and then council lead council for the respondents, Council Chifoka. We also wish to direct that we are conducting these proceedings in an open manner, in public. We are being captured by the answer, so you could tell the vice chair of the board and any other member, even including the side of the petitioner, let us stop personal recordings through our phones. We are being captured unanswered, and we are doing these proceedings in public. Please be advised.
Thank you. We will proceed so that we agree on lost time.
Council, you are being captured unanswered. So if you are too low, we won't actually make any notes for ourselves. So just up your voice.
You may.
Thank you very much, Chair and honorable members. I am Honorable Dennis Mohanga, a resident of Ramp constituency. Ward is Manyakano, Kakamega County.
Mr. Dennis, we are here in respect of your petition dated 6th October. Petition dated 6th October 2023. You confirm your petitioner?
Yes, I am the petitioner.
In respect of the petition, it is fairly elaborate. Do you wish, in the interest of time, to adopt and reiterate the content of the petition?
Yes. Yes. Mr. Chair and the honorable members.
And consequent to that petition, you filed an affidavit sworn on 20th November 2023.
Yes.
Again, in the interest of time, do you wish to adopt and rely on that affidavit verbatim?
Yes.
As your testimony on oath?
Yes.
Mr. Muhanda, pursuant again to your petition, you filed a bundle of documents.
Yes.
Which is in the list dated 20th November 2023.
Yes.
You wish to rely on that evidence in the documents as a bundle as your testimony?
Yes, Chair and honorable members.
Chair, by honorable chair, honorable vice chair, and honorable members, so as not to waste time, we have so adopted. Mr. Muhanda, you may. Chair, I'm the one reading my witness, the petition. And it is.
Yes, proceed.
It is in my decision to decide how the petitioner's case is laid out. You shall never suspect the same. Now, Mr. Mohan.
Yes.
We have referred to the documents in the bundle. You have a list there.
Yes.
Running to documents number 18.
Yes.
Do you wish to produce each of those documents in that list?
Yes.
as exhibits. And will you so produce them?
Yes.
The record may reflect, Honorable Committee, that the documents number 118 in the panel.
Honorable Chair, we wish to object.
100%, please.
Honorable Chair, we wish to object to the supposed documents number 1 to 18 for the following reasons. One, we do not know which document is 1 and which is 18. What was served on us by the committee was a bound document of identified and serialized documents. So identification of the specific documents becomes a huge challenge and an impossibility on reference by the respondents. Secondly, the petitioner is not the maker of these documents. All those documents are government records, documents. The makers are government officers. This objection on the production and the requirement that the specific makers appear before the committee to produce their documents is premised under Section 35, subsection 1 and 2 of the Evidence Act. In addition, we wish to refer to decisions of the High Court. Made by the Constitutional Division of the High Court. Amplifying the basis of our objection that one, documents must be produced by the makers. Two, that public documents to be produced must comply with the requirements under sections 79, 80 of the Evidence Act. And this decision, one of them is contained in Muko Mungai and 4 others versus the official receiver and provisional liquidator, which is captured as a 2019 electronic Kenya law reports, which I wish to produce a copy, and specifically running from paragraph 9 of page 2 of that decision. All through to page 4 of the same. You may wish to be guided by that particular decision. There is also the second decision on the same. In the case of Ezekiel Oira versus Patrick Kwaku, which is a 2017 electronic Kenya law report, public decision, again, amplifying the requirements on production of public documents under section 79 all through to 82. Of the Evidence Act. This was directed in High Court of Nairobi, Civil Suit number 373, 2010, which we also wish to have the Honorable Committee benefit from the wisdom of the High Court. And from the position of the respondents, we have an obligation to assist you walk within the law. It will be a fatality if we let you go on a wild goose chase without putting pieces of law before you to assist you carry out your mandate. And we are saying the petition not being the maker of these documents, these being public documents, then their production in the times of the law. I wish to caution, the committee. I know you, the committee is going to overrule me on the same, but I wish to caution the committee that this is distinguishable from the initial.
Council Chifoka, do you feel that is the direction we should go? Do you feel that is the direction we should go?
Most of the
In your clear conscience, do you feel that is the direction?
I'll go back to my submissions. As I was saying, we have an obligation to present this before the committee so that you are well guided. I wish to also enlighten the committee that this objection at this particular time is distinguishable from our initial objection. Our initial objection was on admissibility of the documents. This is on production that is not properly suited to produce these documents. Thirdly, which forms my third ground for the objection of production of those documents. Some of these documents are correspondences between the county attorney and the board. The county attorney and the county secretary. The county attorney and the secretary of the board. They therefore fall within what we call professional engagements between advocate and client. All organs of the county government are clients of the county attorney. He or she is the chief legal advisor of those entities. Therefore, the conversations between them, and particularly when you look at some of the letters, she explicitly says, I advise, I direct. They then are protected under the section 34 of the Advocates Act. All the way to section 36, including, I think, the Evidence Act as well as the same, the Evidence Act. Just confirm it from me. Of the Evidence Act, not the Advocates Act. Section 34 of the Advocates Act is about who draws what. So, and if a party in his own course, of desired litigation comes across a document between an advocate and the client, and this party seeks to use the same document against that client or the advocate, then it becomes a violation of that privilege and the confidentiality. We pray that the production of all those documents for those reasons is declined, for them being public documents. The makers are known, the makers are alive, the makers are within the confines of the county government of Kakamega. Some of them are seated comfortably and possibly watching the live stream from their offices and their phones. Others, the production of these documents would compromise that confidentiality. I would refer, for example, on the letter dated 14th of April 2023. I don't know whether it remains the same, but it has been marked as DDM1, but it has been crossed out. There is a letter dated 14th of April 2023, the very first annexure on the affidavit. There is also a letter dated for the same date to the chairperson of the County Public Service Board. There is also a letter advising the service board on the action to be taken on the decision of the Public Service Commission that they hold any action until proper directions are issued. The chair, you will have to forgive me. I can't give you specific pages because the documentation is not marked. No pages, no paragraphs, so I can't refer to a specific page. I can only give you the date of the documents being referred to. And that is one of the primary issues we were raising, which we were effectively overruled on the same. And just for clarity, on the basis for objection on those county attorney documents, it is under section 134 of the Evidence Act, which espouses the privilege of advocate and client. So we pray the Honorable Committee that you agree with us that the petitioner is not suitably footed to produce these documents, them being public documents, being uncertified, the procedure of the acquisition not being specified, the requirement for payment for these documents not having been met until the makers come to produce the same. That is all. You have to forgive. I insist. We raised the issue that the petition and the supporting documents do not comply with the rules for not being petinated. So that is why we are having difficulty referring to the sections of that voluminous document. That is all.
Counsel for the petitioner, do you have anything in response?
Yes.
Before we take a determination on it?
Yes, Honorable Chair, Vice Chair, and Honorable Committee. I will respond to the 3 points in objection. The first one is that the documents are not paginated or arranged in a particular order. My response would be that this is a hearing, and documents are being produced. And in the bundle of documents, there is a list. And that list specifically identifies the documents as appears on the list. And that's why we have said from number 1 to 18. Secondly, in the character of these proceedings, the fundamental issue is, are the respondents and their counsel prejudiced by the documents or the manner in which it is arranged? In his subsequent objections, counsel for the respondents is referring to particular documents and particular dates. So if in his objection and in addressing you is that he is able to point out particular documents, inclusive of the authors of those documents and the dates of those documents, I wonder what else you would have wanted us to do. Perhaps put each document in a folder and label and give it. Lastly, on that point, we are proceeding on a hearing today. As at 30th November 2023, when the committee delivered two rulings, a ruling, counsel was already in possession of those documents. He did not ask the committee to direct us to redo that bundle. So he came to hearing today ready to proceed with those documents in his possession. And in asking for time, where we lost about 45 minutes in argument about allocation of time, his point was the time mentioned by the committee would be insufficient for them to address the petition. So I would think that objection at this point, with tremendous respect, is being malicious and is misplaced. The second aspect is on production of documents by the respective authors. On that, we respond by saying, number one, that these proceedings are not subject to the provisions of the Evidence Act. The law in that respect is settled. Number two, the committee is called to observe the Constitution of Kenya 2010, the standards therein, the County Government Act, the County Assembly's Powers and Privileges Act, and the Petitions to County Assemblies Procedures Act only. So that at the end of the day, what the committee should be considering itself with, concerning itself with, is whether the respondents have been accorded their right to fair administrative action, the right to hear. Did they have the information? Did they have the petition? Were they notified of a hearing? Are they represented? Did they participate today? And you can see clearly, Honorable Chair, Vice Chair members, that they are participating vigorously through council. I have not heard them say that some of those documents are ineligible, or they are mentioned in the list but missing from the bundle, or some of them are incomplete, or the substance of the documents are altered. So I think committee should overrule my colleague. The second bit on that is that in terms of the law I have cited, this committee has powers to summon officers or members who are not affected of the County Public Service Board for Kakamega, inclusive of those who will not have testified here today. The reason for that design in the law is that when you present a petition for the removal of a member or members of the board, you will be relying on official documents that are exclusively and peculiarly in the possession of the current office holders. So how would a person, given the right under Article 37 of the Constitution to present a petition, do so if the strictures of the Evidence Act were to be observed. It is for that reason that the framers of the Constitution and the legislation I have cited decided that that act will not apply. As long as you have that information, you present it to the Assembly. The Assembly then takes over. As part of its oversight, it can investigate and it can summon the staff in that order, whether affected or not to produce documents. So as we speak, the process is not yet concluded. The committee has not done its duties. Before determining the petition and filing a report, you still have an avenue of summoning the makers of these documents for verification. So there will be no harm. And by the way, before we go ahead, the respondents cannot stop you from doing so. So if the petitioner presents them here, you have the power to summon members of the public officers who are there to come here and verify the comments with cross-examination of the respondents. And lastly, I am now constrained to complain, Honorable Chair, Vice Chair, and members. You see the kind of time we are spending these kinds of objections. It is strictly for this reason that the design of the law does not allow strict compliance as though we are in court. The decisions which my colleague has cited, I was lucky because I served as a researcher for the Rules Committee back in the day. You will see that the decisions are on objections to production of documents in proceedings in a court of law, not a committee of an assembly. So when applying precedent, the principle in the law is when you're applying judicial decisions, there's something called distinction. You distinguish. Where was the law being applied and for what purposes? The rules governing procedures and proceedings in a court of law do not apply here. So for that reason, I urge you to disregard those two decisions cited to you. And lastly, on attorney-client privilege, my colleague is mistaking his client's membership of the board with the board. For instance, when I'm writing to the assembly, to the clerk or the speaker, I will address it to the speaker. But there is no property in that communication belonging to the speaker, because that office has to be held by a human being. We have not been told that the people who author those documents are complaining that their documents are being used here. And lastly, on that aspect, I invoke Article 196 of the Constitution of the Republic of Kenya and the general architecture of the law. The character of these proceedings are essentially public. The reason being, the County Public Service Board exercises powers that are public in character. You would imagine the kind of helplessness that the people of Kakamega would have if they were to be told that documents in the possession of the County Public Service Board you'll never see and you'll never lay your hands on. What kind of world would that be? Even you, members, how will you then discharge your mandate? If you are told you can never lay your hands on those documents, and part of the documents concern appointment to public office, and part of the documents concern use of public funds.
Finish in the next 2 minutes.
Lastly, committee members, we must make the observation that in law, the documents you're being referred to, in addition to being public, they relate to the respondents who are in office for a fixed term of 6 years. What happens when they leave office? We there again say they'll never be used anyway. So those kinds of objections, in my view, with tremendous respect, are absurd, and that is why the law intended that they do not apply here.
Yes, Council Shifuka, please take a maximum of 5 minutes.
Thank you very much, Honorable Chair. With due respect, the submissions of my colleague from the last hearing on occupancy of public offices and the responsibility of public officers myopic. It is clear that public offices are trusts which are served when the occupant is in. Once he goes, the functions continue, records continue being prepared and being maintained. So whoever takes over still takes over the same. So, I wish to refer the committee to Article 236, sub-article B of the Constitution. Article 236, sub-article B of the Constitution, where it expressly protects public officers from dismissal, from punishment, removal from office, demotion in rank, through a disciplinary process that does not go along the law. It does not limit which law to be applied. You cannot say that you will not apply the law of evidence in the proceedings before the House. Why? Because your standing orders, again, do not provide for how evidence is to be produced. So we only have the Evidence Act, which guides production of evidence across the judicial and quasi-judicial bodies. So, in my colleague again misleading you that the law of evidence, the Evidence Act does not apply, then he will be throwing you into a ditch. You are obligated to obey and respect all written laws. The Constitution, all written laws, and the rules of national justice. So we are saying these documents do not comply with what the law has said about public documents. Thirdly, on the elements of the authors of the documents not complaining, we say that is why we want the authors to come and produce them, so that we have a fair chance to, 1, verify, 2, test credibility, 3, verify the process of obtainment. So in the absence of that, then the respondent shall be subjected to a skewed process. Fourthly, attorney-client privilege. It does not matter whether the advice is to an entity or an individual, for as long as it is addressed to people who are bound to take actions. In the event the advice is not taken, then those documents become privileged. It may be of interest for the committee to interrogate why these makers have not sworn any affidavits to introduce these documents. Instead, we have the petitioner. I had him call himself Honorable, who I don't know whether he was an MCA, an MP, or who, or a judicial officer. I want, in the absence of anything to waive the privilege, then they must be accorded the privilege in that form of communication and rendering advice. The custodian of these documents is not the respondent. The custodian is the secretary, the board, the AG, we have others in the executive. So by the petitioner lumping every document and saying they are the owners of the document, it is not true. The owners are the public. And that is why there is a procedure for the public to access the documents. So far, the sense of the committee summoning witnesses is to seek clarification and have each of the parties have a fair chance to cross-examine those parties. If the petitioner is disinterested in cross-examining the makers of the documents, I wish to assure the committee that the respondents are keen to have the makers properly cross-examined for the purposes of ensuring that the real issues are brought out. Maybe the petitioner has the real petitioner elsewhere, and that is why he does not care whether they are called or they are not called. Lastly, on the element of the documents, production of documents, being limited to court process, I wish to enlighten the committee and my colleague that these are quasi-judicial proceedings. The nature of quasi-judicial proceedings is that you are going to make a decision that is comparable to a court so properly seated. And if you're going to take the position to make judicial decisions, then the same must be made in full compliance and following of all laws. We want to believe the effects of these documents being produced without the makers shall prejudice the respondents in the sense that, one, certain questions which will be asked in cross-examination will be beyond the scope of the petitioner.
Until you have already taken an additional minutes, please conclude.
Most obliged. And two, the respondents will be stopped in their right to fair trial by being denied the chance to cross-examine the makers of those documents for purposes of the circumstances under which the documents were being honored. That is the dual prejudice is bound to be suffered by the respondents. That is all we are.
Thank you, councils. Please accord us 5 minutes, the committee to deliberate on those issues, and then we make our directions over the same. Kindly accord us 5 minutes. Members of the gallery, please accord us some time. Members of the fourth estate, you can also allow us deliberate. However, you may give your gadgets, whatever they are, so long as they are not on, for 5 minutes, and then we'll come back.
Nito. 5 minutes tunarudi. Sasa. Tunatoka. Yep. Kuja tu hapa. Bila shaka mtazamaji, ni kikao cha kwanza ambacho kimekamilika sasa hivi, ambapo mchakato mzima kutathmini utendakazi na vilevile mustakabali wa kikao hiki ama ile bodi ambayo inasimamia waajiri kaunti ya Kakamega itabainika sasa hivi baada ya kikao hiki cha mwisho, baada ya siku 3 za mchakato huu kuendelea katika bunge hili ama chini ya kamati hii ya bunge la County Assembly ambayo imesimamia mchakato huu. Sasa hivi nitakuwa nachukua mapumziko kiduchu tu, nitakaporejea mtazamaji itakuwa na kupatia awamu ya pili, ambayo pia itakuwa awamu ya kufanya uamuzi ni kipi labda mustakabali wapo watautupa mswada huu ambao ulikuwa umewasilishwa na Dennis Muhanda, ama mswada huo utakuwa unaingia katika kitengo kingine. Kwa hiyo mtazamaji, popote ulipo, usiondoke pale, manake tutakaporejea baada ya dakika tu 10 nitakuwa na kurejesha ndani ili tuweze kupata awamu ya pili.